Welcome back, everybody, to Public Law. We're continuing talking about the various sources of the UK Constitution in this lesson. And what we're going to do in this video is talk about the common law. Now, the common law is going to just be a single lesson, just referencing really what the common law is, a couple of the general principles of the common law, which may be said to have constitutional status attached to them. And then we're going to start talking about some of the more subsidiary constitutional issues that have been of prevalence and prominent importance in recent years, the most important of which being the impact of Brexit, the impact of the Gina Miller cases in relation to Brexit, before we then start moving on to talking about administrative law, the concept of judicial review, the grounds for judicial review, as well as terrorism legislation and police powers, all of which are going to be the topic of the next 20 or 30 or so lessons after we have covered the constitutional section of this topic. In this lesson on the sources of the Constitution, like I said, we're moving away from that of the convention on the one hand and the statutes on the other. Arguably, you could make the claim that statute law and constitutional conventions are the most important, or at least the most interesting to talk about, sources of the UK Constitution. The common law is also an indicative source of the UK Constitution, but is one that isn't as controversial as, for example, a constitutional convention. So what is the common law? What do we mean when we talk about the common law? Well, the common law is made up of various different principles and precedents which are developed by judges in legal cases. That is the sort of beginning and end of what the common law is. The common law is home to a great many different legal principles which are said to have this constitutional status attached to them. So the idea of the constitutional element can derive out of the common law. Here's a few examples that we could examine in this particular lesson. One such example is from the case of Burma Oil versus the Lord Advocate from 1965. In this case specifically, the House of Lords was asked and invited to consider whether compensation was owed at common law to an oil company for decisions that were made under the auspices of the royal prerogative. Essentially, and simply put, therefore, this is a case which involved the limits of and the obligations that are enshrined under the auspices of the royal prerogative. To what extent does an oil company have responsibility for decisions which are made by the royal prerogative? This was specifically in relation to the destruction of some property by British forces, and British armed forces were acting in 1965 under the power of the prerogative in this particular instance, and are often acting under the power of the prerogative, and so as the result of which the question of the prerogative authority and the prerogative obligations became one of important and particular relevance in this case. Now, the House of Lords held that compensation could be owed, and therefore created a principle at common law that there is, in certain circumstances, decisions which are made under the auspices of the royal prerogative imply a certain amount of obligation under the royal prerogative for things like compensation. In this specific case, the actions of the royal prerogative involved the use of armed force in certain circumstances, and that this gave way to an obligation on the part of the royal prerogative to compensate an oil company for decisions which were made, the destruction of property by British forces. This is the common law principle, but it should also be noted that the principle was then reversed by statute under the auspices of the War Damage Act of 1965. So note here that where there is a common law principle that is established by the courts, this can be overruled by the basic principle of parliamentary sovereignty, as we note from earlier lessons. Parliamentary sovereignty implies, or at least explicitly states, that Parliament has the ability to make and unmake any laws they so choose. And so if the government believes that this decision is not particularly in accordance with what they want for the common law, or for what they want in terms of their obligations under the common law, they can theoretically get a piece of legislation through Parliament which overrules this particular concept. You can think of a similar instance here when we think about the sinking of the Belgrano in relation to the Falklands War. At which point there was principles that were enshrined that were overruled by the Official Secrets Act. The Official Official Secrets Act essentially providing very little in terms of remedy for whistleblowers in certain high intelligence situations. Again, not exactly the same, but it's an example of how statute can then essentially come in and intervene to implement what the government wishes in the circumstances in which the government has a majority. This, though, speaks to the question of what the role of the common law actually is. The major roles that the common law essentially inhibits, or inhabits, should I say, more broadly, is that of interpretation of statute. So, simply put, the court must, in making a ruling on a various part of statutory interpretation, they must ascertain the intentions of Parliament. There are various different approaches to which the court can actually answer this question of how Parliament's intentions can be inferred through the wording of the legislation that they have created, all of which we have, or at least some of which we have looked at when we discussed the English legal system. There's things like the Golden Rule, there's the literal rule of interpretation, etc., etc., the mischief rule as well, all of which give us an indication of how there is ways in which the courts have been able to imply the intentions of Parliament in the creation of statutes. And so through this, they create law, and some of these laws, just like some of the laws that are created by Parliament, are constitutional in nature or concern constitutional issues, and so as a result of which they form part of the UK's constitutional framework.